Welcome to Week 2, Critique of Unfair Dismissals. During this week, we will be focusing on an evaluation of unfair dismissals in the context of unfair labor practice. In this week, you will read the listed readings and case law while still keeping in mind your learning outcomes of last week. The approach taken in this lecture video is to guide you on how to critique and evaluate a problem scenario on unfair dismissals. The lecture is further meant to assist you with your outcomes for the week by attempting to bring out your creativity with infographics and mind maps. At the end of the week, you would have done the following: appraised unfair dismissals within the context of unfair labor practices, evaluated current challenges facing the interpretation of unfair dismissals, assessed possible recommendations for law reform with reference to case law and a comparison with foreign jurisprudence, and debated the issues arising relating to unfair dismissals. Balancing rights. In the case of Sidumo versus Rustenburg Platinum Mines Limited, the Constitution and the LRA seek to redress the power imbalance between employees and employers. The rights presently enjoyed by employees are as a result of a long haul, which was endured by years of intense and often difficult struggles by workers and their organizations. Neither the Constitution nor the LRA affords any preferential status to the employer's view on the fairness of a dismissal. Constitutional standards, together with the right to fair labor practices, are used to assess the views of either parties to a dispute. Although there is the rule of even-handed decision-making that must be maintained, the approach of the Supreme Court of Appeal tilts the balance against employees. It is a practical reality that it is the employer who hires and it is the employer who fires. The decision to dismiss is a decision taken by the employer, but the determination of its fairness is not. A determination made by an impartial third party on whether or not a dismissal was fair is meant to promote an impartial outcome. Unfortunately, the balance between the rights of these two groups can be troublesome. In the case of Hoffman versus South African Airways, although keeping the rights of the employer in mind, the court held the following: our Constitution protects the weak, the marginalized, the socially outcast, and the victims of prejudice and stereotyping. It is only when these groups are protected that we can be secured that our own rights are protected. Assessing dismissals for operational requirements. Operational requirements is defined under Section 213 of the Act as requirements based on the economic, technological, structural, or similar needs of the employer. The Code of Good Practice on Dismissal for Operational Requirements concedes that dismissal for operational requirements is a no-fault dismissal, which means that the dismissal is by no reason of the action or omission of the employees concerned. You can refer to the code to see how it elaborates on the types of reasons for dismissals for operational requirements that can be provided by the employer. The unpredictability displayed by the various court decisions as to the role of the courts in scrutinizing the employer's commercial decision to retrench operational requirements became lessened by the introduction of Section 189A into the LRA since amendment. Section 189A was actually designed to cater for large retrenchments, and it imposes procedural obligations under Section 189A2 to 5 and substantive obligations under Section 189A(19). Since the 2002 amendment came into force, there is now a distinction between small-scale and large-scale retrenchments. The content of Section 189A, apart from regulating large-scale retrenchments, also places more obligations on an employer contemplating retrenchment, as seen in the Act. One of the factors for consideration is that it must be the only available measure to be taken by the employer contemplating dismissal for operational requirements. Thus, retrenchment, which would have the effect of increasing the profitability or efficiency of a business, has been regarded as fair, provided that the employer is able to prove that alternatives to dismissal were considered prior to taking the decision to dismiss. Section 189A(19), therefore, defines the notion of fair reason for dismissal based on operational requirements. The only question here now that begs clarity is, did the amendment adequately resolve the legal uncertainty in the substantive fairness in the dismissal for operational requirements? The consideration of recommendations facing the challenges with retrenchments. The case law approach has remained split between abstention and intervention in scrutinizing the employer's rationale for dismissal. The abstention and intervention approach, highlighting the court's inconsistency for more than 2 decades, is set out briefly in the following selected cases as discussed. The abstentions approach was used by the courts in Benjamin and others versus Placé Telemat SA Pty Limited. The intervention approach was adopted in Chemical Workers Industrial Union and others versus Algorax Pty Limited. The different approaches used by the courts displayed the inconsistency in this area of the law despite the 2002 amendment to the LRA. This is so because Section 189A did not state that in considering the alternatives, the employer must choose the alternative that would minimize or avoid job losses. Consequent to this statutory indecisiveness, the court's position and approach has remained uncertain. The uncertainty in this area of the law, apart from the lack of statutory clarity, is premised on the nature of the dismissal itself. The decision to dismiss for operational requirements is basically economic and not a legal one, and the judicial officers adopted the view that they were not necessarily the best qualified people to assess the merits of business decisions. While Section 189A may have to an extent put an end to the showing deference approach mentioned above, there is a need for further amendment to bring the law of the substantive fairness for operational requirements into certainty. In view of both statutory and judicial uncertainty, it would be significant to this evaluation to consider the recommendation that can be made to reduce the legislative challenges and the case law uncertainty and find viable solutions to this problem in our law. Conclusion. This lecture video has given you insight into a critical evaluation of a problem scenario with unfair dismissals. Now it's time to apply this week's information to other problem scenarios for purposes of a critique or a critical analysis of them. This will further assist you with completing your tasks for the week. Ensure that you watch the summary video on this week's learning outcomes to prepare you for synthesizing procedural fairness in the next week.